Judgment in the matter of D. A child.
Article 5 of the European Convention on Human Rights provides that no one shall be deprived of their liberty except in certain defined circumstances and with certain procedural safeguards, including the right of access to a court to determine whether the deprivation is lawful. This case concerns a 16-year-old boy who was diagnosed with Attention Deficit Hyperactivity Disorder, Asperger syndrome, Tourette syndrome, and a mild learning disability. Everyone agreed that he lacked the mental capacity to make decisions about his own living arrangements. With his parents' consent, he was accommodated by a local authority under the Children Act 1989. The authority made arrangements for him to live in a residential placement where he was under constant supervision and not free to leave. Everyone agreed that objectively these arrangements would amount to depriving him of his liberty within the meaning of Article 5. The issue in the case is whether his parents' consent to the arrangements means that it was not a deprivation of liberty which attracted the safeguards in Article 5. In other words, does it fall within the scope of the legal powers of parents, known as parental responsibility, to make or to authorize the authorities to make living arrangements for a mentally disabled 16 or 17-year-old child which would otherwise amount to a deprivation of liberty? In the Court of Protection, the judge held that while it had been within the scope of parental responsibility while the child was under 16, once he reached that age, it was no longer so. The Court of Appeal reversed that decision and held that it was. The official solicitor, acting on behalf of the child, appealed to this court. In a judgment handed down on the 26th of September, this court allows that appeal by a majority of 3-2. Historically, the power of parents physically to control their children was a dwindling right which lasted only until the child reached the age of discretion, which was before the age of majority. Lady Black holds that, under the common law, parental responsibility does not extend to authorizing the confinement of a 16 or 17-year-old in circumstances which amount to a deprivation of liberty. Lady Hale prefers not to reach a concluded view on this question in relation to a child who lacks the capacity to decide for himself, but she agrees that it reinforces the conclusion which she reaches under Article 5. Lady Hale, Lady Black, and Lady Arden all agree that Article 5 protects children who lack the capacity to make decisions for themselves from being arbitrarily deprived of their liberty. Parental consent to arrangements which are normal for a younger child may mean that there is no deprivation of liberty, but these arrangements were not normal for a child of 16 or 17. Parental consent cannot turn arrangements which are objectively a deprivation of liberty into arrangements which are not. In other words, parental consent cannot be a substitute for the consent of the person detained. Hence, the procedural requirements of Article 5 applied. In this case, there was no doubt that the parents and everyone else had the child's best interests in mind. But that would not always be the case. Without such safeguards, there is no way of ensuring that those with parental responsibility exercise it in the best interests of the child. Lord Carnworth, with whom Lord Lloyd-Jones agreed, would have held that it was within the scope of parental responsibility to authorise arrangements which deprive the child of his liberty. 2 additional points should be made. First, the court invited further argument on whether these arrangements amounted to placing the child in, quote, accommodation provided for the purpose of restricting liberty, end quote, known as secure accommodation, and thus attracted the more elaborate restrictions and safeguards in Section 25 of the Children Act 1989. But it concludes, for the reasons given by Lady Black, that they did not. Second, as the Court of Protection had authorised the placement as being in the child's best interests, the safeguards required by Article 5 had in fact been complied with. In future, the safeguards contained in the Mental Capacity Act 2005 will apply to children aged 16 and 17, and so this court's decision should not increase the burden on the Court of Protection.